Welcome to another short video from the Liverpool Law School. This time we're going to concentrate on an issue which has shot to the top of the political agenda and looks set to dominate discussions for at least the next few months, and that's the transitional regime between the UK and the EU. Now, on its face, this sounds like a relatively specialist issue, and there's certainly a lot to say. I've just finished a pretty detailed article exploring the issues raised by transition for the Common Market Law Review. But transition isn't just about technical questions. It's actually of fundamental importance to the UK's entire plans, such as they are. Put simply, if transition works, it makes the task of an orderly withdrawal from the EU much easier. If it doesn't, then things could get pretty messy pretty quickly. Now, the starting point for our discussion is Theresa May's speech in Florence back in September 2017, when she called for an implementation period between the date of UK withdrawal and the birth of her new deep and special partnership with the EU. But it was only really after the European Council in December 2017 that the detailed negotiating instructions on transition were adopted for the Commission. Now, at the outset, it's important to be clear about what the UK is not asking for. On the one hand, the UK isn't asking for a direct prolongation of its formal EU membership beyond the 2 years which is provided for by default under Article 50. The date of withdrawal actually remains as planned. On the 29th of March 2019, the UK will become a third country in its relations with the EU and its member states. On the other hand, nor is the UK government trying to negotiate an implementation period in the sense of a phased entry into force of a final deal on future relations with the EU, which would also be done and dusted by autumn of this year. Remember that was the transition regime originally proposed by the government in its white paper of February 2017 and repeated many times since. But of course it was never a credible proposal. There was no prospect whatsoever of reaching a final deal on the future relationship while the UK was still a member state under Article 50 within such a restricted timescale. And obviously there can be no phased implementation of an agreement which doesn't actually exist. Instead, the UK is requesting that the Article 50 agreement, in addition to dealing with citizens' rights and the situation in Ireland and the divorce finances, should provide for a post-withdrawal transitional period which will effectively ease the pain of what would otherwise be both an imminent and an abrupt UK departure. And the government's insistence on continuing to use the phrase implementation period is simply an attempt to disguise its own really quite fundamental political and diplomatic miscalculations in the Article 50 negotiations so far. Now, be that as it may, the UK's request does raise some obvious and important questions. What are the motivations behind the proposed transitional deal? What do we know about the two sides' political preferences as regards the scope and the basis of transition? And what constitutional or legal issues are raised by transition, particularly for the EU? Now, let's start with the motivations underpinning the proposed transitional deal. And here the EU and the UK interests do seem to have converged around two main points. First of all, both sides want to give public authorities more time to prepare for the consequences that will flow from the very fact of withdrawal. Now, most people assume that refers to obvious things like recruiting more personnel and physically preparing ports for the introduction or massive expansion of customs controls. But as our viewers will know from previous videos, the challenges go much further than that. And such is the sheer scale of the task that the UK government has brought upon itself in order to prepare internally for withdrawal from the EU without a serious risk of experiencing wide-scale regulatory or administrative malfunction, that the UK simply needs more time in order to complete the necessary domestic work to the minimum acceptable level of competence. Now, here we're referring not only to the vast amount of complex technical work, policy choices and new institutional arrangements that have to be undertaken pursuant to the already seriously delayed European Union withdrawal bill, simply in order to safeguard basic standards of legal continuity and legal certainty. In addition, the UK needs to design and implement new regimes to govern entire sectors such as agriculture, fisheries, customs, immigration. That's besides reaching agreement on a resettlement of the devolution regimes for Northern Ireland, Wales and Scotland. And of course the challenges aren't just internal. The UK still has a mountain to climb in regularising or rebuilding a wide range of international relations in fields from trade to the environment to security. So we need to be very honest about this. The UK needs transition far more than the EU does. Secondly, both sides want to allow businesses and public services more time to make their own operational preparations for the practical consequences of UK withdrawal. All across Europe, existing supply chains may need to be adjusted, recruitment practices or training needs may need to be rethought, new legal structures may need to be adopted, fresh supervisory requirements may need to be fulfilled. Now here, however, the UK government is perhaps overselling the benefits of transition, in particular by suggesting that it offers businesses the chance to avoid having to undergo two sets of regulatory adaptations. There's absolutely no guarantee that transition will mean only one regulatory change for businesses. It's at least as likely that the transition will have expired and complex but difficult negotiations will still be ongoing about the future relationship, or at least not yet cleared through the multiple hurdles of ratification across the EU as well as within the UK. But anyhow, what is clear is that the UK and EU interests have converged around the principle of a post-withdrawal transitional regime which should, as far as possible, be based on a temporary continuation of the status quo. And that brings us to our next main question: what do we know about the political preferences of the two sides when it comes to this more detailed framework to support cooperation during a status quo transitional regime? And here we can highlight several key points of potential difference. First, in principle, which fields of cooperation will transition actually cover? Now, the UK only ever mentions trade and security, but the EU understanding is much more comprehensive. Effectively, transition will cover the entire scope of existing EU law and policy, subject only to minor exceptions, for example in fields where the UK currently has an opt-out as a member state. Secondly, within those fields of cooperation, what will be the more precise basis for continued cooperation between the EU and the UK? Now, both sides agree that transition simply has to be based on the EU's rules, but the EU actually goes further. For example, insisting that union law should continue to produce the same legal effects within the UK as it does across the rest of the EU itself. And that means continuing, for example, with principles such as direct effect and supremacy, the principle of loyal cooperation between national and EU law, effective judicial protection for individuals, presumably also the Charter of Fundamental Rights. And so the government, it looks, will have to put on hold many of its plans under the European Union Withdrawal Bill for the duration of transition. Similarly, the EU insists that the UK should be automatically obliged to follow any new changes in EU law during transition, and there's scant interest in any British desire for a screening or filtering mechanism on this point. Now, those who screech that this would reduce the UK to the status of a vassal state, if they were at all capable of rational self-reflection, would actually be explaining to the British public what happened to all of those promises about the UK holding all of the cards in these negotiations. Now, thirdly, the UK has nevertheless made several specific suggestions to deviate from the status quo during transition. Some of those suggestions are relatively uncontroversial. For example, the UK wants to be able to enter into formal trade negotiations with third countries, provided that the date of entry into force of those agreements only comes around after transition. In fact, the EU has even held out the possibility that certain new UK agreements could enter into force even during transition itself, provided the EU agrees. But after all, the EU probably doesn't have very much to lose here. The UK isn't likely to achieve very much during transition, given that our main focus is actually on trying to persuade third countries simply to copy and paste existing EU agreements over for the benefit of the UK, subject to whatever concessions they can wring out of us by taking advantage of the government's relative inexperience and apparent desperation. And then implement those agreements into UK law through the fairly sweeping powers of executive decree, which Liam Fox would like to claim under the Trade Bill. So the EU probably isn't giving that much away. Potentially more problematic is the situation concerning the free movement of persons. Now, the EU's position here is robust. Not only must free movement continue in full during transition, but in addition, the so-called specified date for the purposes of calculating entitlement to protection, future protection, under the citizens' rights provisions of the withdrawal agreement should be the end of transition, not just the date of withdrawal itself. Now, the UK government's precise position here remains unclear, but Theresa May has certainly indicated in public that even if the UK is prepared to accept a temporary continuation of the free movement of persons, it will not extend the specified date from withdrawal to transition. So this has the potential to become a real sticking point in the negotiations. Fourthly, what would be the institutional arrangements governing transition? Now, the European Council has been very clear. Existing EU regulatory, budgetary, supervisory, judicial and enforcement mechanisms must apply. But the UK would no longer participate or nominate or elect members to the Union institutions. And in addition, although the UK is being offered operational participation in the EU agencies, for example in fields such as medicine or chemicals, it will not have any decision-making or governance powers in those agencies. Again, the basic price of transition is clear. The UK has to transform itself voluntarily from being a leading rule maker into being a passive rule taker. David Davies has tried to push back. He's demanded that there should be ways to ensure that the British voice is still heard in Brussels, but he hasn't yet offered any concrete proposals. In any case, the UK has resigned itself that it would remain subject to the continued enforcement powers of the European Commission, the continued jurisdiction of the Court of Justice during transition. But the government has suggested that the powers of the court in particular should be replaced as soon as possible with some alternative, again, unspecified dispute settlement mechanism. Now, many lawyers find it really quite difficult to fathom the irrational hatred of the European Court of Justice that seems to torment the waking hours of your average British Europhobe. But so far, the EU has shown not the slightest inclination to accommodate this type of political shenanigans. And on the contrary, as I wrote in my piece for Common Market Law Review, the EU actually has a good case to push for even stronger powers of enforcement against the UK during transition. For example, the possibility of suspending parts of the agreement as a penalty for systematic misbehaviour. So it was interesting to see in news reports over the last few hours that that's exactly what the EU is now considering to propose. Fifthly, what would be the duration of the transitional regime? Now, the UK government says around 2 years. The EU 27 have suggested a defined transitional period when the European Parliament said a maximum of 3 years. But we now know that the EU proposal has crystallised around a period of 21 months, expiring by the 31st of December 2020. Either period, the UK or the EU proposal, is a lot shorter than many businesses would prefer, but so far there seems to be little, if any, support for an explicit facility to extend the duration of transition should a real pressing need arise. Finally, what would be the territorial scope of transition? Now, it remains to be clarified whether transition could also benefit those overseas countries, such as the Falkland Islands or the Cayman Islands or Bermuda, that currently enjoy a certain special status in relation to the EU through UK membership. But the main question is, will the EU 27 allow Spain to exercise a de facto veto over extending any transitional regime also to cover Gibraltar? So, although the two sides agree on many of the key principles of transition, there are some very important political differences that remain to be bridged. But transition isn't just about politics. The EU 27 have also said that any deal must be legally possible. And some influential voices have expressed concerns about just how far transition will be compatible with the legal powers which are conferred upon the EU under Article 50. So let's just highlight a couple of the main issues. First, an ambitious transitional deal is almost certain to touch upon issues of national as well as EU competence, and one would normally expect such a mixed agreement to require national as well as EU level ratification. Now, if that were true, the whole process of transition would suddenly become much more cumbersome, much more prolonged, and much more uncertain. However, the Council has decided that Article 50 is actually an exceptional provision which allows the EU to negotiate and conclude a withdrawal and transitional agreement on behalf of the Member States, acting alone without further national ratifications. Now, that's a very convenient political understanding, but it does remain vulnerable to challenge, for example, by a disgruntled Member State, should the unity of the EU 27 break down at a later stage in the negotiations. And here, the UK's apparent strategy of trying to divide and rule the rest of the EU has actual real risks as well as potential benefits. That division could come at a real serious cost for the UK if it does lead disgruntled member state to challenge the legal competences of the EU in relation to withdrawal itself. Secondly, EU constitutional law tries to insulate the internal functioning of the EU's institutional and legal system from external interference or influence. And these principles would become relevant if the UK pushes too hard. For example, asking for special privileges that aren't normally available to third countries, such as full decision-making powers in the EU's medicines or chemical agencies, or arguing that references to the Court of Justice from British judges should only be advisory in nature, they must be binding. Thirdly, and perhaps most difficult, Article 50 adopts the fundamental premise that the treaties will cease to apply to the UK at the moment of its withdrawal when it becomes a third country. But the UK EU plan for transition is based on a very ambitious wholesale extension of EU law to the UK, just as if it were still a member state. There's no proposals to try and construct a freestanding or comprehensive system of EU-UK cooperation mechanisms that would try and give a more specific legal expression to the ambitious political desire for a status quo transition. Far from it, the plan seems to be that vast tracts of the EU treaties and union legislation won't actually cease to apply to the UK from the moment of withdrawal, but will be extended wholesale to the territory, the public authorities, the citizens of a third country. Now, there are very good practical reasons why that is the proposal, given how much there is to do and how little time there is to do it. But it remains very difficult to square with the explicit text of the treaties, and again remains vulnerable to legal challenge. Now, perhaps the two sides should explore potential other creative solutions to express their political preference in a more legally compelling way. Consider the possibility that the withdrawal agreement could provide for different dates of entry into force for different provisions. There could be one date for UK withdrawal from the EU's institutional structures, but a later date for UK withdrawal from the substantive rules of EU law, for example, the single market and the customs union. But in any case, we should also bear in mind some important practical limitations to the utility of a transitional agreement between the EU and the UK. And in particular, as we mentioned before, there's immense uncertainty about the UK's future status in relation to the EU's existing international agreements, hundreds upon hundreds of them covering everything from trade to aviation, the environment, security, many of which are applicable only to the EU and its member states, and would therefore cease to benefit the UK at the moment of withdrawal unless all of the relevant parties agree otherwise. Now, a transitional deal which is fundamentally premised on the transformation of the UK into a third country wouldn't in itself do anything to help solve these problems. And both the EU and the UK seem to have acknowledged that they can't oblige other countries or other international organisations to carry on treating the UK just as before, at least not without their consent. Again, maybe it's worth looking at other creative solutions to this problem. For example, different dates of entry into force for different parts of the withdrawal agreement could actually help solve many of these problems. So let's wrap up. For both legal and political reasons, the negotiation of an ambitious transition may well prove more difficult, more controversial, and indeed take a lot longer than many UK politicians seem to assume. And definitive answers to many of the tricky legal questions can only be provided by the Court of Justice in Luxembourg. But judicial action, even if it were done urgently, would only slow matters down even further. And so either way, some of the main benefits to having an ambitious transitional regime may prove more difficult to deliver in practice than they appear in theory.